Last sessions for the afternoon. I'm going to introduce my colleague Eva Plurkova in a second. First session is about the SGHA 2023. New revision, new edition of the SGHA is in progress and coming. So I'll introduce Eva and the team just to give us the actual news and the updates about what's in discussion, what we can expect from the new SGHA 2023. I'd like to welcome Eva Plurkova to the stage, the head of standards and operations here at IATA. Eva, welcome.
Good afternoon, ladies and gentlemen. I was kind of hoping that no one comes back from coffee break, so you slightly disappointed me. We thought we could cut it short. So let's talk SGHA. I am pretty confident from many of you in the room that it's probably most referred document during this conference. Seeing the negotiation in exhibition hall and business zone, I would put my $5 on it. We have esteemed and very knowledgeable panelists today who will provide you updates on SGHA, as well as give you some practical tips how the SGHA can help you, or perhaps cannot help you, in legal litigations. Please let me welcome on the stage Christina Marku, Airport Service Commercial Agreement Manager from IGN Airline. Give her a clap, please. Next speaker, Peter Butler, Vice President Commercial Cluster Switzerland, France from Swissport. And last and not least, speaker, Michael Tagelhoff, I hope I did it right, Attorney at Law, Legal Affairs from Airport Munich. So before we start to SGHA, let me demystify how the SGHA gets updated. SGHA is part of Airport Handling Manual, and as such is updated within its governance. We have a working group and task force which are doing the standardization work. So in this case, it's Ground Operations Standard Task Force, which have an experts from airlines and handling companies. We have a procurement and legal experts who participate in working in the contract team. Some of them, Christina and Peter, are members. Michael is our guest. This task force work on proposals, argue if they should or should not be included in the next revision. If they are, we work together on proposal, and everything has to be agreed by the team as we work on principal consensus, as well as it goes for approval to the ground operation group. We have equivalent participation of the handlers and airlines. Recently I received email from someone, oh, it's handler driven. Next email, next day, oh, it's airline driven. So no, it's 7 companies are handling companies, 7 companies are airlines. As you know, SGHA is revised on 5-year cycle, but we are doing also annual updates, and we are publishing them in AHM 11, yellow pages as an optional text. Quick one, how many of you use or know about AHM 811? Hands up. I'm pretty sure there's a ghost task for members. Okay. Thank you so much, but at least some of you did. So not to make it long, let's us look at the what is ready for 2023 revision, and Christina, who is a team leader of the contract team, will brief us on definitions and main agreement changes, or proposed changes as it was not approved yet. Christina, to you.
Okay, thank you, Eva. So on definitions, and I'm not going to stay on those which are already included in yellow pages. We have amendments. We have added a new one for return to ramp, as this might affect the service and the costs involved with it. Then we have new definitions for travel documents and transportation documentation documents in order for them to be aligned with ICAO Annex 9. Arrange for and cargo were already included in yellow pages, and supervision coordination are new definitions we worked on as a team. We have slightly revised the text on those two, because what we discussed within the team is that more and more it is the case that supervision and coordination as a service is contracted nowadays not only for third parties, but directly from the same handling agent as well. Then from main agreement, which the important ones are Article 1.6, which is related to emergency assistance, and there we got the help from emergency response experts. So this article has been revised. Then in Article 5, Standard of Work, we worked on it not only this year, but also the previous years, and the whole article has been amended, so you will find a lot of changes in that. The majority of those changes are already included in yellow pages, though. And then we have Articles 11, 12, 11, 13, 11, 14. I'm not going to stay in those now because we will discuss that in a while. So this is definitions and main agreements, main amendments.
Thank you, Christina. Let's zoom on some of those. We will not have time to go through of those, but some of those. So let's zoom on IGOM and AHM, or 5.6 and 5.16. 60% of airlines, I think Monica mentioned it before, already announced that they implemented Chapter 11. So, Peter, Swissport proactively implemented AHM Chapter 11, which is ground operation training requirements, into your operation. Where do you see benefits, operational as well as commercial, if there are any?
Mm-hmm. Now, Swissport, as mentioned, has aligned all its procedures to IGOM, which is aligned again with AHM Chapter 11. Now, for us, it means a standardization, a big step forward in standardization, which has many positive effects. One is it reduces differences in interpretation, and it reduces the risk of confusion among our staff working daily with various airlines at the stations. So at the end, we could summarize that this has a big effect in efficiency, but as well in effectiveness of training. And we believe as well that for the carriers, it has exactly the same advantages, more effective, more efficient, and all of us, we need to work on our costs. And this is really a good move forward to accept this training we have aligned with IGOM and AHM Chapter 11.
Thank you, Peter. Christina, you as an airline, one of first 8 airlines who published the gap analysis within the IGOM portal, where do you see the benefits? Why do you think, what was the benefit and why we put the IGOM into the SGHA?
I actually see many benefits in implementing IGOM, as Peter said, and I totally agree with Peter. IGOM brings consistency in operations, IGOM implementation, and especially on the ramp side, and consistency brings efficiency, which is something we all need these days. Now, as you said, in Aegean, we already implemented IGOM. We found out that we had some minor differences, just a few, but the rest are more or less the same. Now, from contracting perspective, the way I see it is the contract is a tool not only for us, the contracts people, where we need to know what we have to contract, but it is also a tool for the operational people because they need to know what services are to be provided from the handling agents, and also which services are the carrier's staff have to oversee. So if we all speak the same language and the services we contract are cross-referenced to the procedures and we all know what we are talking about and we are talking about the same thing, then everyone's job becomes much easier.
Thank you. So we pretty much closed the loop between operation and commercial, which we were trying to do for a long time, and finally it happened. Let's move to the topic, other topic, adjustment of the changes. Christina, do you want to brief us again what was the change?
Yes, of course. Very briefly, 11, 12, 11, 13, some minor amendments in the wording. What is new, though, is 11.14, which is a new provision to 2023 version, and it talks about the right of both parties to amend the charges in case there is a difference in processes or in the procedures.
Peter, 1114, what it means for you as a handler? Is there such an issue or changes in the manuals and processes from airlines?
Yeah, 1114 is indeed, I think, a good move, and it's not only good for the ground handler, it's good for the carrier as well. We have to remember that in our days, contracts are concluded over many years, and so many things can change in the meantime, as we have seen in the recent past. And it simply states that in case of changes of procedures, we can enter discussions to find joint solutions to adjust the price. But as well, in the other way, if you look at automatism or efficiency gains from the airline side, if suddenly no check-in is needed anymore because you have just devices, self-service devices, then it also gives the right to the airline to start discussions with the ground handling company to adjust the costs. So it's in fact a very fair article, and what is important, it needs to be mutually agreed. So it's not a one-way road where you can imply something. It's really a mutual discussion to find solutions.
Thank you so much. Michael, from the legal point of view, so can handler come and increase the charges to the airline, or can airline automatically demand decrease?
Well, first of all, thank you for including me in the discussion now. Well, Peter has already given part of the answer, right? The way you have worded the new articles, it says, either party shall have the right to request an adjustment. So there is no automatic adjustment. We are in a contractual situation, and the parties obviously both have to agree to any adjustment they make, otherwise you don't have an agreement. But the way it is worded, I would say, is that there is an inherent bias in favor of an adjustment. So the other party would only be able to decline such adjustment if they have reasonable doubts that the requested adjustment is too much.
So thank you very much. Remember, it's negotiation. So the right is there, but it's not guaranteed. Let's move to the next one, next slide. Let's zoom on liability waiver for sanctioned carriers. As we understood, some handlers might face an almost financial, almost existential problem in case they cause the damage to the airline, and their insurer might deny paying the compensation to the airline, or might refuse the coverage of damage compensation for carriers from sanctioned countries. So Peter, how do you deal, what is the issue with the sanctioned countries are you experiencing in your operation?
I have to state first, it doesn't happen too often, unfortunately. But indeed, it's a very uncomfortable situation. On one side, you have usually you have licenses at the airport, which requires that you fulfill handling services for airlines operating to this airport. On the other side, there are indeed sanctioned carriers operating, and where we have clear instructions to not handle those airlines, being it by our owner or by somebody else. So it's a very uncomfortable situation where we need to find a pragmatic approach. Could be that, for example, the airline is the airport is the party who gives the order to handle the aircraft, but not the airline itself. But as mentioned, it doesn't happen too often, but it can happen. And of course, there are other questions like liability, which was mentioned, which is a different story.
Thank you. Michael, your company work for airport, right? So are you mandated to provide the services to the carriers? And did you have a situation? How did you deal with that?
Well, we are the airport operator, but we are under the duty to provide services to each and every carrier that has a right to take off or land at our airport. So it's in the hand of other parties to decline those rights to carriers, such as Eurocontrol or the air navigation service providers.
Thank you so much. Christina, so where are we with the discussion? Because we didn't come to a conclusion yet, it's a discussion.
Yes, it is. It recently came to the group, and we are in very initial stage of the discussions. We are considering adding a provision to somewhere in Article 8, which is related to liability. But on the other hand, we are very skeptical on amending Article 8. So there are also thoughts of adding it in Article 11, something like what we have today with regards to bankruptcy, sorry. But as I said, we are still in very initial stage of the discussions. So we will see how that will go.
Thank you. So I can confirm the discussions are fairly, how I'd say, vivid between we should not do it, it's a commercial discussion, we should do it because it's a point. So let's see where it goes. Next topic. We discussed a lot, not everything makes it. So again, I will ask Christina to walk us through what we discussed for main agreement and did not include.
Okay, so this year, what we discussed were mainly concerns which came after COVID and which were raised during the COVID. So we had discussions about SLA applicability during force majeure cases. We also discussed if we can tackle the issue of amending the charges with adding a provision for those cases. Then we concluded that we don't need to amend anything because charges amended are now covered under 11.12, which is related to reduction of frequencies. We also discussed about carriage of cabin and cargo. Then we agreed that we should not amend anything because it is a temporary service and it's not going to be forever. And the last one was related to data privacy, GDPR. Then we found out that each company uses its own document. It was very difficult to simplify it and incorporate it in the standard ground handling agreement. So we did not finalize anything with that either.
So if we don't agree, then we don't proceed, or we do agree but don't find the right wording. So that's how the process is. If we move to the another slide, which talks about prepared changes for Annex A, and I think next one is for Annex B. So Christina, if you can take it.
Okay, so very briefly, I will not go through everything, but only the important ones. We have amended 223, which we will see in a while in detail. For excess baggage, what we have done is we removed the paper documents because it's not an industry standard anymore, and if it is in some cases still used, then it can be addressed in Annex B. Transfer counters, what we did, we removed connection services because this item is related to the transfer counters as counters and not as a service. Then we worked on baggage tracking 3.1.10. We made it more clear and in order to comply with IATA Resolution 735 as well, and we added the locations. We are working now and we are trying to have it ready for 2023 interior cleaning. We don't know to what extent that will be amended yet. And then what we have done the last 2 years is we reviewed completely Section 5 cargo. So Section 5 cargo will have a lot of changes in 2023. The majority of those changes are already in yellow pages. And then we reviewed entirely Section 7, which is related to security. And this is also going to have a lot of amendments in the next version.
Sorry, I didn't click on the next slide.
Yeah, sorry. And one last thing about ticketing agreement. Ticketing agreement today is a separate document. But what we discussed as a group is that more and more ticketing services at the airport become obsolete or they are simplified. So we have agreed to incorporate ticketing as a service in the standard ground handling agreement. Some parts of the ticketing agreement which are related to terms, they will be moved to the main agreement, and the services will move to the Annex A.
Thank you. We also restricted Annex B paragraph 1 and 2 layout. We figured out the line maintenance. Well, they are technicians, right? So engineers made it more organized, so we adopted it. If we move, let's zoom on travel documents. Travel documents is like kind of evergreen in our group. I think we discuss it every single year for some changes. It's item 223, if I'm not mistaken. Peter, what are the experiences before COVID, after COVID? I know that it's a nightmare for handlers, nightmare for airlines.
Yeah, you mentioned evergreen. Evergreen is usually something positive. This one, not that much. No, it's a really difficult topic anyway. And instead of traveling becoming easier, it became more complicated with a lot of countries putting more restrictions on traveling, on checking documents, and so on. And particularly the COVID situation was an extreme example of a negative impact. We all know the process times at check-in increased heavily, not enough check-in counters, not enough staff, unhappy passengers, unhappy airlines, unhappy ground handlers. And the operational consequences are really heavy. A part of the above the wing situation, it also has an impact on the ramp side, offloading baggage of passengers being refused at the gate because of missing documents. And here, it would really be nice if there are more solutions around which are automated, which as well removes the responsibility from the ground handling companies to the passengers, that travel becomes easier again.
Thank you. So let's look at the changes which we have in progress. And I am pretty sure that I will just say something, and my colleague Catherine Cannon from NATA will hate me, but she's in charge for this item. So if you have any comments, please identify yourself. But to Christina, brief us on where we are and what the changes are.
Okay, so what we did is now we have checked travel documents. As we said, travel documents is also a new definition which is aligned with ICAO Annex 9. Then we have separate the residence cards or visas, and we have added a third one, which is related to health documentation. So when we were discussing this item in the group, we had a concern if this is something temporarily or if this is something which we are going to use in the future. But we concluded that this is something we already use in some cases for some countries, so it's better we have it there. Now, what it didn't change, though, is liability. Liability is the same as it was in 2018 version, and it does not check of health documents does not affect liability. It's only for passports and visa as it was in the previous version.
Thank you. So please remember that travel documents as per ICAO Annex 9 only consider passports and identification documents. So travel documents are not health documents. Michael, we identify that the waiver from or exceptions from liability should not be in Annex A, because Annex A are list of services. We are in debate where it should go. So from legal point of view, where do you think we should place it?
Well, usually if you ask several lawyers, you get several answers. But if you only ask me, I would say, I would say it's pretty obvious, it should go into Article 8 of the main agreement. If you look at the system that's already reflected in Article 8, you will find that it basically lists different liability scenarios, whether the ground handler is liable or whether the carrier is liable. And from a legal point of view, it would simply makes sense to add an additional paragraph with regard to the travel documents. And I know that there are reservations, but I have not fully understood why there are reservations to include it there. So.
A huge reservation. we are a bit afraid of Article 8, I would say, touch or change. Nevertheless, if any of you have any input to this one, and Catherine, are you in the room? She's not in the room, but I'm sure that most of you know her, so you can provide us with the feedback if you have any suggestion where we should place it. Thank you. Liability, it actually brings us to the different topic. And Michael is so kind, and he will provide us with some practical tips on how to be prepared if you are facing to legal litigations and the use of SGHA or role which in those litigation has. So, Michael, to you.
Thank you.
I probably sweat the thing
Yeah.
for you.
So, first of all, thank you, Eva, once again for inviting me. I was surprised and pleased to receive that invitation and to attend such a down-to-earth business conference. So it's an honor for a nerdy lawyer to give a presentation here. So thank you very much. So I would like to talk to you about the lack of acceptance of the SGHA in selected jurisdictions. And I have two cases in particular for you that we're going to look at today, one from Germany and one from Italy. But first of all, it all starts, and you're probably aware of that, with a real-world problem. And that's usually some kind of accident. So something obviously went wrong here, and I don't know exactly how nobody saw that coming in that particular situation. However, accidents happen, and usually they are dealt with very, very smoothly by the insurance companies involved. But occasionally, a real dispute evolves and reaches the courts, and then that court has to find a solution. So the cases we are talking about here are always cases in which there is damage to the property of the carrier caused by the ground handler. And the clauses applicable, as you probably all know, are Articles 8.1d and 8.5 of the SGHA. And it's always important to keep in mind that the SGHA is a mere template. So it's not a regulation, it has no legislative characteristics whatsoever, so it's always subject to interpretation by national courts pursuant to national law. So as a brief reminder, in plain language, Article 8.1d provides that there is no compensation for damage to property unless caused at least recklessly and while being aware of the probable occurrence of damage. Article 8.5 is an exception to that clause and provides that in case of simple negligence, the ground handler is liable for damages to the aircraft between $3,000 and 1.5 million. Now, that being said, as a reminder, let's turn to the first case from Germany. Again, same situation, aircraft damaged by the ground handler. What happens in Germany? In Germany, the judges feel tempted to intervene if you have a contractual situation on the side of the weaker party. And when they realize, the judges, that the contract was based on general terms and conditions, they have, under German law, the ability to intervene. So the question is the SGHA in any given contractual situation, does it represent general terms and conditions? And whenever the judges detect a deviation from what they have coined the entrepreneur's cardinal obligations, they tend to strike down that clause, and that has happened to Article 8. So, to be clear, the precise cardinal obligation in question here is that an aircraft ground handler must not use language in its terms and conditions that exempt the ground handler from damaging aircraft to the level of gross negligence, because that, in the eyes of the courts, undermines the contractual purpose. So what can you do about that when you face such a discussion, maybe even in court? There are mainly two tests that you can raise. The first one being, do we have general terms and conditions at all? We all know that the SGHA was developed under the leadership of IATA, which is obviously the international trade body of the airlines. So one idea that came up in the court discussions was whether there was an inherent bias in the SGHA in favor of the airlines. But if you take a closer look, you will find out that was not the case. Eva has already mentioned it earlier. The committee is evenly, or in the committee, carriers and handlers are evenly represented. So the decisions they take and what is later reflected in the wording of the SGHA has been agreed unanimously. And we also see it in real life. Usually both ground handlers and carriers are happy to use the SGHA in everyday operations. So if you can show that, in fact, it was a unanimous decision to agree on using the template, then you don't provide the judges with the chance to intervene because they can only do so because of general terms and conditions case law, which wouldn't apply then. The second test is a material test, and you can ask whether the limitation of liability in general terms and conditions is justified. And the answer can be given by conducting an economic analysis of law. So in every contractual situation, you usually have a cheapest cost avoider with regard to possible damage and a cheapest insurer. The cheapest cost avoider is usually the party that is closer to the risk-prone activity and that can prevent the risk from materializing at lower cost. In our situation, that's usually the ground handler, because the ground handler has to train its staff, but also has the influence to train the staff, and can ensure that safety measures are followed, etc. On the other hand, you have the cheapest insurer. That's the party that can take out insurance coverage against that possible risk at lower cost. And that can be the same party as the cheapest cost avoider, but that's not necessarily the case. So if there's only a low probability of a loss occurring, it may be more efficient from an economic point of view for the risk to be assumed by the party that can protect itself against the consequences of its realization at lower cost than the other, in particular by insuring itself against the occurrence of the threatened loss at lower cost. And if you take a closer look at Article 8 of the SGHA, you will find that these ideas are actually reflected in the wording. And it's the same principle that the German Supreme Court has accepted in previous decisions from other industries. Now, let's have a quick look at a case from Italy. The case that I've picked here was particularly striking because the Venice Appellate Court granted a tort claim and even for consequential loss. And you should know that lawyers do, at least. Sorry. Tort claims that can be raised in a damage situation, a damage scenario, are usually excluded if there is a contractual clause that excludes this particular liability. Because otherwise you would always be able to undermine the agreement that the parties have negotiated and executed. So tort claims are usually excluded, but in this particular case, the Venice court decided that it was appropriate to grant damages on the basis of torts and even for consequential loss, which is clearly excluded pursuant to the wording of Article 8. And the reason the Venice court gave was that in its view, it was a different legal interest that was protected under Italian tort law than the legal interest protected under the SGHA. The court held that here it was severe reputational damage to the airline due to the sheer number of passengers that had to be rebooked when a flight had to be cancelled. And so the interpretation of Italian law by the Venice court was that it could grant damages for consequential loss on the basis of Italian tort law. So if you take a step back and ask yourselves, is that the proper outcome? I would say, if you have a look at the history of the SGHA, the drafting history, and how everything came about, what we nowadays have, it becomes apparent that also for this scenario, consequential loss had to, or it was the intention of the parties to exclude consequential loss. So that's something one should raise to Italian colleagues when the next case has to be pleaded in court. Now, as a brief takeaway for you, so you can prepare for your next SGHA negotiations, or maybe when you're facing litigation one day, what should you consider? Take preventive measures for new contracts. Always try to document the negotiation process. Take minutes. Who suggests using the SGHA? Is it a unanimous decision? Take a note of that, or maybe even include that in the preamble, and take the documentation possibilities provided by Annex B or Annex B simplified procedure seriously, and really do the writing. For existing contracts, try to recap the above information and save it. If litigation looms, check who is responsible. Is it the legal department in your organization? Is it the insurance department? Or is it the external insurance company? Possibly all of the above. So align early and exchange information as quickly as possible. Sometimes it may be worthwhile bringing in special counsel, maybe a transport or aviation law specialist, because if you only look at the wording of Article 8, the SGHA is not really easy to understand and has in particular a very nested structure. What else could help? Tell the story, the history of the SGHA. The wording of Article 8 was based on the wording of the Warsaw Agreement. The Warsaw Agreement, which is still in force today, granted far-reaching exemptions of liability and limitations of liability to the carrier. So it is my argument that a necessary service provider of such carriers, without whom the services, meaning air transport services, couldn't be offered to the general public should also be included in the umbrella provided by the Warsaw Agreement. The legislator in your jurisdiction has almost certainly transposed the Warsaw Agreement or similar agreements into national law. Look it up. How exactly has it been transposed? What's the scope of that particular legislation? And in particular, check contracts of carriage legislation, because many of the tasks that the ground handlers provide on a daily basis are in fact tasks that can be attributed to a contract of carriage. So that's my brief insight into the legal arena. Vielen Dank. Thank you very much for your attention, and I hand back over to you.
Thank you.
Thank you. Thank you.
I said that we have everything balanced. I have to make sure next time we give the practical tip to airlines too. It's gonna next year agenda. What we did, for different topic, we said we are gonna look and ask what the users say. So we have posted a poll on LinkedIn before the IGHC a week ago, and we have asked you how you use SGHA. And what we were particularly interested, if you customize SGHA, because it was mentioned by Michael here that might not be particularly understandable and might be sometimes complicated. So we wanted to know how you use it. So 61% of you said that you are modified slightly, 28% significantly, and 11% of you are using it as is. I would like to ask as a closing question to all our panelists, starting with Peter and going through the end with Michael. Are we, as a GOST task force, and you personally as an expert in this area, for customization or not?
When we look back at the history of the SGHA, some very far-sighted people created it, that everybody understands the same, and I'm a strong supporter that this SGHA should be used as it was created for, with no amendments. And when I look at the results, my experience, the 61 and the 28 are reverse. But for me, it's clear. It's a pity that we have more and more deviations. It makes our life difficult. And just to add one thing, when I'm employed by a big company who has lawyers who could deal with it, but not everybody has these means and tools. But I'm a strong supporter of the genuine SGHA.
Thank you, Christina.
I agree with Peter. And as I said earlier, the Standard Ground Handling Agreement is a tool, and it is a tool which has been developed to standardize the way we do contracts. And talking as the person who is doing the contracts for Aegean, if I keep receiving, and if I'm receiving contracts which have completely changed or amended or deviated from the Standard Ground Handling Agreement, then it becomes more and more difficult to handle. Then I have to take those contracts to the legal department. It will take months, if I'm lucky, for a further review. So we need to treat the Standard Ground Handling Agreement for the reason it has been developed, and it has been developed years. 50 years ago, it was the first attempt to develop the Standard Ground Handling Agreement. And if you think that from the 23 version to 2023, it has been already 20 years that we all use the agreement. And after 20 years, we receive documents which have been amended that much. And yes, something is wrong here.
Michael?
Well, I totally agree with what both Peter and Christina have already said. So I would advise against customization, but I'm realistic enough to know that, and to a degree I've already talked about it, that it might be necessary to customize it here or there if you positively know that it is required. under national law to tweak it a little bit so you have it enforceable afterwards, because otherwise it wouldn't serve its purpose. But I absolutely would discourage any attempts to change it significantly, because then the purpose of it gets lost.
Thank you. Just in brief summary, you have got some very brief insights on proposed changes. I just would like to remind you that they are not approved yet. We finalized many of them, but they will be still going under approval. Those which are in yellow pages, 811, they are already approved. They will go automatically into the SGHA 2023. SGHA 2023 will be published in AHM edition 43. It will be out at the end of this year. You also got, especially handlers, got some very good tips how to deal with the litigation. And last and not least, I would like to invite everyone who significantly modify SGHA, please get in touch with us. We would like to hear from you, learn from you what is the reason to do so, because everywhere is a space for improvement, and I think it's an opportunity for us to look at what we could change if the modification is across the board in the same areas. With that, please give a round of applause for our speakers. Thank you very much.